The Honorable, the Judge of the United States Court of Appeals. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention to the court is now sitting. God save the United States and the United.
All right, be seated, everybody. Good afternoon, everybody. Welcome to the Fourth Circuit. We have 3 cases on the calendar this afternoon, and I also want to welcome my good friend and colleague, Judge Bill Traxler, who is appearing remotely with us this afternoon. Good to see you, Judge. All right, the first case is Gray versus, United States versus DeRosso. And Mr. Gray, whenever you are ready, sir.
Thank you, Your Honor. It may please the court. Your Honor, this case is fairly simple. This is about the plain language of a statute, 922A5. And the plain language of the statute requires that the government ultimately prove beyond a reasonable doubt that Mr. DeRosso had transferred to another person or entity a firearm. And the language of the statutes, it's quite clear. When we take a look at what the statute requires, it requires ultimately within its first element that the defendant wasn't a licensed firearm exporter or importer. But the second element requires that the defendant transferred, sold, traded, gave, transported, or delivered a firearm to another person. And as we see within the charging document here in this indictment, the government alleged that that transfer was to the Haitian Army. Based upon the record that was developed at the trial, there was no evidence to indicate that that transfer had been completed, including through the statements and testimony of my client, Mr. DeRosso, as well as the evidence that was shown during the course of the trial. There was no intent to make that delivery to the Haitian Army. Yet that is how the government ultimately charged.
Mr. Gray, you just used a word that's slightly different from transfer. You used delivery, and the statute does account for various methods by which it may be violated, including delivery. And I guess my concern is how do we differentiate between these various methods of violating the statute? If a transfer is something short of a delivery, then when is it complete? Or is it your view that a transfer actually has to be completed via delivery of a firearm to a different person, in which case it would seem to subsume the other definitions in the statute?
Well, Your Honor, I think the best way of looking at it, to use a phrase that we're seeing more and more common day, is the idea of a supply chain. What Congress's intent was with regard to this statute was to try to find a way of punishing each and every actor that could be involved along the pathway of a delivery or transfer to another person. And I think it's important to understand that the to another person is an important portion of the statute. It's not only in there to identify that there has to be either the sale to, delivery to, transport to, or gift to, but ultimately, when we take a look at elements 3 and 4 of the statute, they ultimately discuss the role of the transferor, the person who is being delivered to or being transported to, or the firearm is being transferred to. When we look at the issue of the transfer, it identifies that that person must not be a person who ultimately was not licensed to be an importer, manufacturer, a dealer, or a collector, and that transferor cannot reasonably believe that the transferee, the person who received the firearm, did not reside within the defendant's state of residence.
So who did counsel put aside the charging document for a second, just on the statute? Did somebody receive, some person receive the firearms?
Your Honor, no. In this case.
So where are they? I mean, they went to somebody, they were intercepted or by the authorities. Does that constitute, putting again aside the constructive amendment charging document issue, if they were received by the Haitian government, perhaps not the Haitian Army, aside from your indictment argument, would that satisfy the statute?
In this case, no, Your Honor. And when we take a look at what took place in this case, When Mr. DeRosso arrived at the airport, he was originally turned away. When Mr. DeRosso had to draw attention to the fact that there were firearms that were there, but there was no completion of the delivery. And quite frankly, it was more of a surrender to law enforcement authorities at that point in time. So it's not the intended transfer, sale, delivery, gift, or devise as charged, Your Honor. And I think ultimately where Your Honor's question is going to is whether or not we have the completion of an offense when those firearms don't go from Mr. DeRosso to an intended person or entity. And Your Honor, it seems as though that the congressional intent was clear. They did not include attempt in this statute for whatever reason. They didn't include attempt, but they did contemplate that there was the delivery of or transfer of or the transfer to another person or entity. And in this case, that just didn't happen.
Well, what's the difference between delivery and transfer? Isn't your view just reading transfer out of the statute?
No, Your Honor, because ultimately a transfer to has meaning within the statute. In this case, we don't have that transfer.
So what would have been sufficient in your view to violate on these facts? How much further or farther would your client have had to go to have completed a transfer?
If Mr. DeRosso had come into the country, seen a member of the Haitian army, delivered it to them, then we would have had the completion of the statute.
That's a delivery. It's not a transfer.
Or if Mr. DeRosso had come into the country, had transferred them to an agent that he knew was going to make the delivery, we would have a completion of the statute. Your Honor, ultimately, what Congress is trying to address is the movement and transfer of these firearms within their borders. That was clear within the Gun Control Act as to the statutory desires of Congress. Congress wasn't reaching out to say that we should, in fact, restrict the movement of these firearms to other countries. In fact, Congress came up with other statutes that address that very issue. And Mr. DeRosso was, in fact, convicted of those very same statutes. Counts 1 through 4 are all involving the export, movement, trade, sale, gifting of firearms outside of the United States. And ultimately, if the court's concern is that there's no repercussion for any sort of criminal conduct engaged in by Mr. DeRosso, that is satisfied by the convictions within counts 1 through 4. But ultimately, Your Honor, when we take a look at what we have with count 5, that was not a completed element. There wasn't a completed element. Therefore, a conviction based upon that conviction is inappropriate and can be we would argue, is a miscarriage of justice. When we look at the bigger picture, Your Honor, congressional intent and the plain reading of the statute doesn't make it that complicated. When we're looking at the intent and goal and purpose of the statute, it was there to make sure that those who were giving guns away to folks who shouldn't have guns, they're punished. But in this case, we didn't have the completion of that. And that's why we cited within our brief the James case, which shows that when you start to make that transfer and that transaction isn't completed, ultimately, there's no conviction and there's no crime there. So, Your Honor, we would argue that in this case, the elements have not been satisfied. There has not been sufficient evidence to indicate that. And ultimately, the court should vacate that finding of guilty as to that count 5.
So, counsel, let's assume we agree with you hypothetically. Help me with what would happen. I mean, you're suggesting we should vacate count number 5. How does that change things the way the sentence was? He was sentenced, as I understand, 60 months under counts 1 and 5, and 63 months under is either 2 or 3 or 3 and 4, and you still have 1. So, I mean, even if we agree with you, what's the kind of the practical effect of vacating 5?
Your Honor, I think one of the most practical effects is we have a finding of guilt that a person has to carry with them, that the government hasn't met its burden.
Sure.
We clearly have a miscarriage of justice, and the courts do not stand for that sort of thing. But if we want to look in terms of just practicality, every count of conviction carries with it a $100 special assessment. $100 in lieu of the number of months he's going to spend in custody. there's some debate as to what feels worse. But ultimately, there's still a loss by Mr. DeRosa, whether it's the special assessment, whether it's the earning of a conviction. And part and parcel of why Mr. DeRosa went to trial is because of the nature of the convictions he would have to carry. I was his counsel at trial. I was the person who helped advise him and walk him through all the stages of trial, including walking over the nature and the evidence and the elements that the government must prove beyond a reasonable doubt if he goes into court. Mr. DeRosa was a Marine who was proud of what he did, and he did not want to take a guilty as to things he didn't do. One of those things he didn't do was impersonating an officer, and the jury ultimately found that to be the case. He also did not want to be found guilty of trying to pass off goods and arms to an entity that he certainly did not want to pass those arms off to. That's why he won and fought very hard as to count 5. And Your Honor, ultimately, that finding of guilt is based upon an instruction that instructed the jury to consider an attempt after the district court noted that you cannot find someone guilty of an attempt under this statute. That was very clear. And this was something that the jury had a lot of concerns with. The jury asked the question not once, but twice. Once on the first day of jury deliberation, they asked the question about whether or not the court or whether or not the jury should consider whether or not his intent and whether or not there was an attempt involved. Because the jury's question was pretty clear. It said, provided that the court did not, provided that the government did not prove that there was a delivery. I think that's very significant because that shows that even in the face of the instructions from the court, the jury had concerns about whether or not the government had met its burden beyond a reasonable doubt of presenting any evidence as to that issue. And then that, unfortunately, that confusion was compounded by the court when the court ultimately instructed the court to consider whether or not his intent to deliver was appropriate. And that, Your Honor, unfortunately, is just another way of asking and advising a jury about attempt. And that's very shocking because in this case, even the district court had acknowledged that there is no attempt in this case. There's no attempt that can be proven under this statute. And that the court can identify within 522 of the joint appendix. So when we look at how we got to the conviction, even the way we get to that conviction where the jury clearly has concerns about the sufficiency of the evidence, ultimately moved the jury into a position where it was erroneously placed. And that, Your Honor, is ultimately why we're here. The plain language and plain reading of the statute is pretty clear, even to the extent of what the intent was with regard to the question of what's a state. The statute identifies what a state is, and it says those that are within the territory of the United States, including Puerto Rico and the District of Columbia. I think it's of note that the statute specifically excludes one international presence. It specifically excluded the Canal Zone. This court in Colicchio ultimately said that when it looked at the intent of the Gun Control Act and 922A5, the intent was to allow the states to manage the movement within their borders, and found that there was a need that transfer take place between the states, whether it's from North Carolina to South Carolina, North Carolina to Florida, and ultimately have that transfer take place there to a person who was not licensed or otherwise authorized to take it.
Mr. Gray, do you know why the statute excluded the Canal Zone?
Well, Your Honor, it appears that from the legislative history that the intent was to maintain at least within the United States and those areas that are pretty much contiguous to the United States, Puerto Rico being kind of close. But Your Honor, when we take a look at some of the areas that are specifically excluded, at the time this statute was proposed, the Canal Zone was still within the territorial jurisdiction of the United States. It wasn't until the 70s that President Carter ultimately gave the Panama Canal back via treaty back to Panama. So there was the ability for Congress to say, we're including the Panama Canal Zone, we're including territories such as Guam, America Samoa. But Congress, more importantly, did not take that step.
I'm sorry. I guess I had maybe read somewhere that you were the trial counsel. You just reminded me about that. So with respect to the arguments that were made in front of the jury, was it your position from the get-go that because the firearms never made their way to someone in the Haitian army, that as a matter of law was an insufficient, that the evidence was insufficient to convict?
Yes, Your Honor, I argued that in my closing. During the course of the questioning of Mr. DeRosso, we asked that question specifically. Was it his intent to make the transfer? He said it wasn't. Ultimately, Your Honor, our argument was based and our objection was based on the idea that there was insufficiency of the evidence at the conclusion of the government's case, and also before the jury got the evidence so that they can make a determination.
Now, the government suggests, I think, that the fact that the weapons did make themselves to someone in a position of authority, in this case, the Haitian National Police, that should be sufficient to have a consummated offense. What is your, other than, I mean, I think I know what the obvious answer is, but do you have anything else you want to add?
Well, Your Honor, I will say this, that prior to being over here at Federal Public Defender's Office, I was an AUSA in that same office. And one of the things that this court has always imposed upon those who are prosecuting is that you have to choose your words wisely and you have to prove your case beyond a reasonable doubt. In this case, the United States chose to place the words Haitian Army in there. The United States could have picked Haitian Police. The United States could have picked the version of transportation security that Asia has. They could have even chosen a different entity or a person or anything in particular, but that was the government's choice, Your Honor. And ultimately, it was the government's choice in terms of how they wanted to prove that burden. To change that choice, to change that decision, ultimately is a constructive amendment. And we've made that argument within our reply brief, Your Honor, to a sufficient degree. So I won't labor in on that. But ultimately, Your Honor, when we look at how this case was proven, with regard to count 5, there wasn't sufficient evidence for that, Your Honor. But if there is a desire to find a wrong, counts 1, 2, 3, and 4 were that. Thank you.
Thank you, Mr. Gray. I'm going to ask Judge Traxler if he has any questions of you before I let you sit down.
No, thank you, Judge Diaz.
Thank you, Your Honor.
Mr. Gray, I will say this. Some lawyers who move over to the defense side after spending time with the government never quite make that transition all that smoothly, but you appear not to have had that problem. Thank you for your argument.
Thank you, Your
this
Honor.
afternoon. Mr. Shanker.
Thank you, Your Honor. May it please the court, Vijay Shankar for the United States. Your Honors, with all due respect to my colleague and friend, I found it telling that he focused entirely during his argument on the words transfer and deliver in the statute. He read the word transport right out of the statute. And as the Eighth Circuit made clear in its James decision, there are multiple means of violating this statute. Now, what we charged here was a transport to the Haitian Army, and we can probably reach that question of who actually received the firearms in a moment. But we charged a transport. And if we may, this is a sufficiency claim here. So let's look at what was proven and what the defendant did. He actually said that his intent was to take firearms to Haiti and train the Haitian military and national police. He actually did fly with weapons to Haiti from the United States. And he actually did have weapons end up in the hands, sorry, removing my mask, of the Haitian National Police.
Judge Diaz, can I ask a question at this point?
Absolutely.
Mr. Shanker, at what point was the offense complete? When he drove out of his driveway with the weapons on his way to the airport, and then, of course, as you just related, all the different incidents, at what point was the crime complete, in your view?
In our view, Your Honor, and I understand this is a difficult question. There are multiple ways to approach this. Our position would be that the court could certainly rule based on the statutory language and the nature of transportation as a continuing offense, that the offense was complete once any level of transportation to the intended recipient occurred. And so,
although he drove out of his driveway, in your opinion, he would be guilty.
I think a jury could certainly find that, Your Honor, and I think that
I want to know what the law is. I know what juries might do, but what's your opinion as to what the law is, and when is the offense complete?
I think the offense could be complete once the defendant takes any level of transportation, including out of his driveway, to the intended recipient. Now, I understand that that's a little bit of an aggressive reading of this statute, and I don't think it has to be reached here. What we have here is a defendant who actually ended up in Haiti, his intended destination, and the location of his intended recipients. At the very least, one could read the statute to say that once the defendant has reached a location where it is reasonably likely, or one could reasonably expect, that his or her intended recipients could come into possession of these weapons, that the offense is complete at that point. But I think our position at the very least is that transport does not require actual delivery or transfer of possession.
What's the purpose of to another person in the statute based on your reading?
Yes,
You suggest transport is being read out by the defendant. You know, I understand that argument. I think transport means something different than those other terms, and agree it has some connotation about the movement of something from one place to another, and that's different than those other terms. So I mean, I get transport's different, but it seems to me your reading of it all but eliminates to another person.
Well, I think there's two and there's another person. Now, we clearly have the intent here to provide firearms to another person. The another person is the recipient who is not licensed. And
but we're not talking about intending to. The statute says that you do it. You do one of those things. It's not what you have in your mind.
Right. Yes, Your Honor. So sorry if I misunderstood.
No, sorry.
So two, I think I'm just trying to separate the word to from another person. We don't intend to read the word to out of the statute. To is a directional preposition. And so in our position, a defendant, for example, who has this intent, I understand intent's not all of it, but has this intent to, let's say, take firearms to Haiti, goes to buy the firearms at his or her local gun store, and then brings them back to their house. Now they have the requisite intent and they have engaged in a transportation, but they haven't engaged in a transportation to the intended recipient at that point. So that would not be a violation of the statute. So our position doesn't read the word to out of the statute. It just requires some level of a directional movement in the direction of the intended recipient. And we have that here. I mean, we have much more than that. We have actual arrival in the location. But to use Judge Traxler's hypothetical, I think if the movement out of the driveway is in any way part of the transportation to the location where the intended recipient is, then that satisfies the word to in the statute.
Well, let me hypothetically assume you're right. How does that not constructively amend your indictment?
Well, Your Honor, as I said, the defendant did arrive in Haiti with the firearms here. Now, the variance is what I think it is in proof at most would be that the firearms were taken to the Haitian National Police rather than the Haitian Army. And right. And we would submit that that is at most a non-fatal variance. There is still a violation of the statute. All of the elements of the statute are met, but what the government proved as a violation, it varied from what was charged in the indictment. Now, that's a non-fatal variance.
Mr. Shanker, let me ask you a question. As I understand your argument, you're saying that the word to means toward.
Exactly.
Am I accurately summarizing your position?
That's correct, Your Honor.
Why didn't Congress just use the word toward?
Well, Your Honor, if the words in our view are synonyms, then I can't speak to why Congress chose one or the other, but these are synonymous words. And if we accept that to means toward, then in our view, it doesn't matter that Congress chose one over the other.
Okay, I understand your position. Thank you.
Thank you. Now, Your Honors, I would like to go back to the question of preservation here. Now, my colleague said that it was his position in the district court that there was insufficient evidence to show a transport to. But with all due respect, again, this was never raised in any of his Rule 29 motions before the district court. The only basis for the Rule 29 motion was that the statute required a domestic transfer.
But even if we agree with you on that point, isn't it the fact is that the district court engaged with the argument, didn't he? So why isn't that enough to preserve the issue?
He engaged with it with respect to the jury instruction solely, and not with respect to a sufficiency claim. Now, a traditional sufficiency analysis by the district court would involve applying the facts to the law and seeing what a reasonable jury could have found and what the reasonable inferences from the evidence would have been. And the district court didn't engage in any of that. Even to the extent that the district court addressed some of the law on this issue, that wouldn't relieve a waiver, the effect of a waiver. And effectively, when a defendant moves under Rule 29 on a specific ground, this court's cases say he or she has waived all of the grounds. There is some case law saying that when a district court passes on an issue, it might relieve or excuse a forfeiture, but it can't do so for a waiver. And so if the defendant did in fact waive this argument, then this court really should only consider it for a manifest miscarriage of justice, which again, given the facts that we have here, which was the fact remains that this defendant accomplished exactly what he set out to accomplish. He took firearms to a foreign country, to Haiti, and they did get into the hands of Haitian authorities. That's a very dangerous prospect. Haiti, as we all know, without casting any aspersions, is in a great deal of turmoil now. It is not considered a very safe place. These guns ended up in the hands of the Haitian National Police. There is quite a deal of overlap with the Haitian National Police and the Haitian military. And these guns could have gone anywhere, really. And those are the very ills that Congress set out to prevent in passing this statute.
So can I go back to, and I guess both of my colleagues' questions about the theoretical reach of the statute and the potential, worst case scenarios that might or might not apply. I find that all very troubling because we have to decide this case, obviously with respect to the parties that are in front of us now, but we also have to be cognizant of what might lie down the road. And you seem to be saying that, well, at least with respect to this statute, that the court just simply should trust the government as to how far the reach of the statute should apply. And, Judge Traxler gave you the example of someone leaving the driveway, but let's say in the scenario you posited that the defendant purchased the weapons with the intent at some point to transfer them to the Haitian army. He brings them home. He goes to bed, and that morning he decides, I'm going to the airport. Today's the day. So he gets out of bed and walks to the bathroom. Under your scenario, that would seem to be enough, wouldn't it?
Well, I think in that particular hypothetical, it would not be enough. I don't think we would have shown. I don't think a reasonable jury.
Why not? He's taking a direction toward to the Haitian army. He's gotten up and getting ready to get dressed and about to leave the house.
I don't know if he had the firearms on him at that point. Perhaps in your hypothetical, he does. He's carrying the bag from his bedroom to the bathroom. I understand these are very difficult line drawings.
Well, it's precisely because it's a difficult question that the answer might be that we simply don't accept the view that any minimal level of transport is enough and that the words to a person mean something in this context.
And that would be a reasonable reading of the statute, Your Honor. I was simply offering one potential reading of the statute. I think a perfectly reasonable reading of the statute and where this court could come out is the other one, the alternative that I proposed, which is that a transport to a location where it is reasonably likely and reasonably can be expected that the intended recipient could come into possession of the firearms. That's the evil that Congress was really trying to foreclose here. Now, what we are really arguing, though, is that transport cannot mean the same as actual transference or delivery, because otherwise you're reading the word transport right out of the statute.
But why can't, certainly, I think you acknowledge that there can be overlap in words. And can't transport be it seems to me as the process of getting the firearms from where they start to where they're supposed to end. The other terms seem to be more like the actual handing over. And it seems to me they all could involve the firearms actually getting to the intended recipient. It's just covering the waterfront along the process from beginning to end.
They do, Your Honor, but to read transport coextensively with transfer would render it a nullity. There
Fair
could be some
enough.
overlap.
Right.
And so if we read transport in that way, we would be really immunizing from prosecution under this statute someone who, for example, on behalf of the actual owner of the firearms, carried the firearms all the way to the intended recipient, dropped them off in the woods there, left the scene, and then the recipient came and picked them up. Now, it was the owner of the firearms that actually transferred possession to the firearms because the mover did not have possession to transfer. But that's very much within the evils that this statute is meant to cover. That person who carried these firearms all the way to a place where the intended recipient could very well come into possession of them, but he or she did not actually transfer them. But to say that because they didn't actually turn over possession to the intended recipient, they're not covered under the statute, I think is just not right. If the court has no further questions, we'll rest on our briefs. Thank you.
I have one more question.
Sorry.
If we were to accept the defendant's view of how this statute would be should be construed, then this crime would not be complete until the weapons were turned over to the person in Haiti, to the Haitian army in Haiti. So that means the crime then would be committed in Haiti. Now, where is the indication in this statute that Congress intended this particular statute to have extraterritorial effect?
Well, I agree with you, Your Honor, and I think that's a reason not to give this statute that reading. I mean, I think that's part of the reason that once the transportation has begun, and transportation, again, is a continuing offense, and I realize this, again, is the most aggressive reading of the statute, one that we have suggested the court need not approach or adopt, sorry. But if the transportation is a continuing offense and begins domestically, then that removes any extraterritorial implications from the statute. Now, even if the transfer, the handing over the firearms is really the completion of the offense and it takes place in Haiti, I'm still not sure, though, that this would be an impermissible extraterritorial application of the statute. This is a U.S. citizen who began the crime in the United States. He or she failed to be licensed under U.S. law. He or she purchased the guns in the United States and then left the United States to transfer these firearms to someone who does not live in or reside in the state that the defendant lives in. And I think that would be a domestic application of the statute.
Okay, thank you.
Thank you, Mrs. Shanker.
Thank you.
Mr. Gray, got some rebuttal?
Yes, Your Honor, just briefly. To help answer the question that was posed by Senior Judge Traxler, I think it's important to recognize that the reading out the two within the statute will virtually nullify the third and fourth elements that are out there that deal with the transfer. And under the government's reading, that's what they're asking. Ultimately, under the government's reading, Mr. DeRosa would have committed this crime the minute he drove out of the parking lot of the gun store in Jacksonville, North Carolina, irrespective of who was receiving it, how far he goes, how far he went, or what his desires were. And that's trouble. The congressional intent on this is pretty clear in the plain language of the statute. The goal was to try to prevent the transfer of arms from one state to another to allow the states the opportunity to help regulate that sort of movement so that they had a role in ultimately maintaining the safety within their borders. With regard to the question of, well, how does Congress ultimately address the issue of the movement of firearms internationally? Your Honor, that's been done. That's what the Export Control Act does. It's specifically there to help address that area. And in this case, Mr. DeRosa was found guilty of that in counts 1, 2, 3, and 4. Ultimately, what we have here, Your Honor, is a charging decision that ultimately did not get met. The government wanted to try to prove that, They did not have the evidence to prove 922A5. And accordingly, Your Honor, it's appropriate for this court to vacate that conviction and remand back to the district court for appropriate proceedings. With respect to the government's statement as to our waiver, more specifically my waiver, during the trial, the district court, and there's no, the JA is replete with references that the district court exactly knew what it was trying to address. And ultimately, the district court, and the purpose of waiver is to allow the district court the first opportunity to address these things. In this case, the district court did so. And when we take a look at the question of what was the district court addressing, did the district court address the issue as to sufficiency of the evidence? The JA on page 22 has Mr. Kalmanovich saying, Your Honor, may I just say, just for the record, in the light most favorable to the government, I submit that every element or substantial element to satisfy to get to this jury at this point. And then that's when the district court ultimately said, they're all going to the jury. I said, I'm taking it under advisement. All counts are going to the jury, but and I anticipated Mr. Gray with renewing his motion. And he did so by nodding his head. Within that brief moment, we see the district court ultimately understanding my argument, ultimately rejecting my argument, and doing so after hearing the specific question as to the sufficiency of the evidence. And Your Honor, ultimately, the problem that created was the court understood that there was no attempt within the statute, ultimately allowed the jury to receive this issue. They had questions, and then the court ultimately advised as to the attempt, and that's what the jury came back to. So, Your Honor, based upon the plain reading of the statute, the government did not meet its burden. It did not provide evidence in order to meet its burden beyond a reasonable doubt, and we think it's appropriate and argue to this court that it should vacate the conviction as to count 5 and remand to the district court for proceedings. Thank you.
Thank you, Mr. Gray. I want to thank both counsel for their able arguments this afternoon. Although we would typically come down from the bench and greet counsel in the interest of safety, we're not going to do that this afternoon. But on behalf of the court, thank you very much for your arguments.
Thank you, Your Honor.
Thank you.
We'll proceed on to our second case.
And may it please the court. Dante Oliver presented significant evidence that while running away, he reasonably believed he was shooting at men who were chasing him with guns and were going to kill or seriously injure him or his girlfriend. These men had engaged in a pattern of escalating aggressive conduct throughout the evening. Minutes before Oliver fired the shots, 5 or 6 Jamaican gang members attacked him inside and outside a nightclub after one of them had harassed his girlfriend all evening. One of the gang members, Smith, pointed a gun at Oliver and a security guard during the attack, causing the security guard to flee in fear for his life, and the club owner to send Oliver back inside the club because he feared for Oliver's life. Oliver then fled out the club's back door, jumped off a balcony, and attempted to escape the gang by meeting up with his girlfriend in the parking lot of a nearby KFC restaurant. But in the meantime, the gang members overheard his girlfriend talking to him on the phone and followed her to the KFC in 2 cars and on foot. So Oliver briefly got into his girlfriend's car at the KFC, but he immediately fell out of the car when she pulled away in a panic before he was all the way in the car. Oliver then grabbed a gun from the car, told his girlfriend to leave, and continued running away from the men while his girlfriend drove ahead. He ran back toward the back of the Pollo Royal restaurant and only stopped running away for a moment when he turned around to fire at one of the gang members' cars when it approached him and his girlfriend's car. And none of the men who were chasing Oliver cooperated with police or testified at Oliver's sentencing. The government doesn't dispute that Oliver presented some evidence that he acted in self-defense, or that the government bears the burden of disproving self-defense in this case. But the district court made at least 4 statements demonstrating that it was not applying this legal framework, and that instead it allocated all of the burden to Oliver to prove self-defense. So first, even though Oliver, even before the sentencing hearing, had supplied the court with PSR objections and witness statements setting out the facts that supported his claim of self-defense, the district court said 3 times that the government had no burden to make the defense's case, and self-defense was the only case that Oliver was making. Next, after hearing the testimony, and again consistent with its view that the government didn't bear any burden relating to self-defense, the court told defense counsel, you could have called the defendant to fill some gaps, but you didn't. That was your choice, so those gaps exist. And it went on to rule that a lack of evidence of other firearms at the scene tipped the scale in favor of applying the enhancement.
Well, counsel, why does that, at least the discussion, I mean, I agree the discussion before the testimony is a bit confusing on the burden, but the discussion there is more general. It's on enhancements, and there's really not the granular discussion of self-defense. That does become the subject after the testimony. And the district court, in response to the comments that, filling in gaps and him not testifying amounts to a shifting of the burden, says, I'm not shifting the burden. And what at least one reading seems to me could be that, he just finds the evidence did not meet, was not sufficient to, constitute self-defense. In other words, you look at all the evidence and it did not rise to that level in the district court's view. I get your arguments that there's, good facts that support a self-defense, argument, but, arguably there's facts on the other side, and the district court found they're not met. He never said the burden had shifted. And it seems like you're asking us to assume he did when when he addressed that very issue and said, no, I'm not. The evidence just doesn't, in my view, rise to that level.
I think that that doesn't distinguish this case from the Adepoju case where the court actually articulated the correct standard, but then didn't apply it. But here, I think the court also articulated the wrong standard. And if you look at exactly what the court was saying in that exchange that occurred before the testimony, he said it 3 different times. And then in the third time he said it, he said, in my reading of the PSR, your defense is not consistent with the relevant conduct section. The government's responsible for proving relevant conduct, but is not responsible for your legal arguments, the factual basis for your legal arguments. So I think that's a pretty clear statement that the district court misunderstood that once Oliver presented some evidence of self-defense, and that is a very low bar under North Carolina law, right. that the government then had to disprove self-defense. But in addition to that, when you look at what happened after the testimony was presented, the court mentioned Oliver's failure to put on evidence of what happened during what it referred to as an evidentiary gap, but it never mentioned the government's failure to do so. And that's the real problem here, that the court recognized that there was an evidentiary gap, and it applied a presumption from that gap that went against Oliver instead of against the government.
Could that have been read? Well, I guess you can tell me. A lot of the evidence here was circumstantial, wasn't it, as to whether or not who did what to whom? Might the district court have been talking about that, the fact that that the evidence here is circumstantial, and to the extent it is because the defendant in this case didn't tell us exactly what happened.
I think that in some aspect, in some sense, that was what the court was saying, but the problem is the court failed to recognize that the government also had access to witnesses and did not put them on. So it was not up to the defendant to prove what happened in those moments before the shooting. Once he put on some evidence of self-defense, it was the government's burden to do that, and they couldn't because these supposed victims weren't cooperating. They were repeatedly telling false stories, and in the end, wouldn't cooperate with the government to testify. And I think it's reasonable to infer the reason they weren't cooperating is because they were trying to hide their own illegal conduct and using guns during that encounter. Under United States versus Adepoju, the district court's burden shifting error requires reversal. And if anything, the burden shifting is worse here than in Adepoju, because here the court expressly placed the burden of proving self-defense on Oliver. In Adepoju, the court actually stated the correct burden, but then misapplied it. And here we actually have a mistaken, the court mistook the legal standard for applying the self-defense.
Can I ask, so if your argument is correct, can we just look at the state of the evidence in the record and decide for ourselves whether or not the government met its burden on self-defense?
Well, no, the court can't, because it's the government's burden of proving that any error was harmless, and it hasn't even alleged that, much less demonstrated it. Plus, that's not the standard that the court should apply in addressing harmless error. The question is whether the error had some effect on the outcome, and it certainly did, especially where the court recognized there was a gap in the evidence, and it laid that gap in the evidence at the defendant's feet instead of with the government, as it should have done.
So the remedy in your case would be to send the case back and have the court reassess the self-defense evidence, applying what you believe to be the proper burden?
I think in this case that the correct remedy is to vacate it and remand it with instructions not to apply it, because if the court looks at the correct legal framework of placing the burden on the government, it can see in the record that the government did not present evidence to contradict what Oliver said.
Okay, so now I think you're agreeing with me then that we look at the evidence and decide whether or not it was enough. And if it wasn't, you win. If it was, the government wins.
I just don't think that there is any scenario in which the government can win under the correct legal standard. That's what I'm trying to convey to the court. But even in addition to its its legal error in allocating the burden of proof, the district court also made a clear factual error when it relied on its finding that there's no other evidence at the scene of any other firearms. And the only relevant factual question to consider here is, was there evidence that Oliver's pursuers had firearms at the scene? And if the answer is yes, and it is, then the district court's finding there was no evidence of other firearms at the scene is clearly erroneous. And there was
Doesn't your argument there, and it may depend a little bit on what at the scene means. Yeah, I think you're right. You pointed already in your beginning remarks to testimony about a gun being pointed right outside the bar around the fight. There was some at least movement towards the parking area where, after that fact, I granted it's not crystal clear, but when he says there's no evidence of the firearms at the scene, is it not fair for us to interpret that the district court's talking about where the shots were being fired as opposed to right outside the bar's door?
I don't think so, because that's just not what the court said. I mean, if that's what the court meant, it should have said that.
At the scene. So I guess
but there was evidence of other firearms at the scene. I mean, there's the circumstantial evidence that there were firearms at the bar and these same men followed him minutes later. It's not a reasonable inference that they would have chased him
without them
and left firearms behind. No, that's not a reasonable inference that they would have put the gun down. That really defies logic. So the court should vacate Oliver's sentence because of the district court's legal and factual errors in calculating the guideline range. And if it does that, it doesn't need to address the Oliver's challenge to the supervised release conditions. But if the court does address those conditions, the court's errors require resentencing under Rogers and Singletary. The government concedes that the district court's written judgment conflicts with its oral rulings at sentencing, and under Rogers and Singletary, the proper remedy for that error is a full resentencing. And that remedy makes particular sense in this case because the district court here has recently overhauled its list of standard conditions.
But counsel, can I appreciate you bringing that to our attention in the 28J letters, but before you get there, do Singletary, Rogers, do they deal with a situation like this where there's a variance between what is spoken at the sentencing hearing and the reduction of that to writing? We can see what the judge said at least about two of the special conditions at the sentencing hearing. They don't show up in writing. Are you saying that if that's the only issue we had, assume that was the only special condition we had, have to send that back just to conform the writing to the oral pronouncement of the special condition?
No, I'm really not. I'm just saying that in this case, it makes sense to do that because of what the district court has done in this particular circumstance, which is to overhaul all of these conditions. And it also, if the court does that, it prevents the court from needing to address the constitutionality of the risk reporting condition because the district court's already decided on its own to stop including that among the list of standard conditions.
But would that mean any special conditions issued prior to the change need to be sent back? No.
I don't think so. I mean, I think the court retains the discretion anyway to readdress those on the motion of the defendant in the first instance. I mean, the court can modify conditions at any time. I'm just saying in this particular case, there are a lot of problems with these supervised release conditions. The error in the difference between the oral and the written judgment is only one of the problems. That only deals with two conditions. There are 4 conditions at issue here. The judge didn't explain any of them. He didn't respond to the defendant's objections. I'm just suggesting to the court that in light of all of the circumstances in this case, it makes the most sense just to vacate those and send it back and let the district court deal with it again. So in conclusion, we ask the court to vacate Oliver's sentence and remand to the district court for a full resentencing.
Judge Traxler, you have any questions of Ms. Hester?
No, thank you, Judge Diaz.
Thank you, Ms. Hester. Mr. Enright?
Thank you, Your Honor. May it please the court, Anthony Enright for the United States. District Court appropriately found that Oliver possessed his firearm in connection with another offense when he used it to shoot Akeem Smith in an occupied vehicle. I heard Ms. Hester speak about the sufficiency of the evidence, but I have to say I understood the reply brief to disclaim any reliance on the sufficiency of the evidence and even criticize me for addressing the issue. So I would suggest that to the extent the defense has introduced the sufficiency of the evidence to support the court's finding, the defense has abandoned that by specifically disclaiming it on page 1 and page 7 and 8 of the reply brief. That said, I'm happy to discuss it. The evidence was certainly sufficient to allow the district court to find by a preponderance of the evidence that Oliver fired into that vehicle and was not being fired upon so as to act in self-defense. Oliver was on video shooting. There were multiple cameras. None of them showed the car. All of the shells recovered matched Oliver's gun. He got into Stone's car, retrieved the gun. She said she wanted to go away. He got out of the car, armed himself for a confrontation. The court could infer from that he simply wanted to confront them and was acting on his own intent. And he falsely denied ever even being at the club, not just falsely denied a firearm, but falsely denied to the police having anything to do with it. The court could infer from all of that he wasn't acting in self-defense. But the issue the defense says is the only issue in the appeal. Did the court apply the correct standards? The background principle is, I think, something this court alluded to, which is you don't presume that the district court got it wrong. The law, Walden versus Arizona, you presume that the district court knows the law and applied the law correctly. And the court certainly didn't say anything about applying the burden incorrectly. Properly placed the burden on the United States from the beginning. There was a discussion before the evidence was presented about, because both of us had presented objections to the pre-sentence report, who's going to go first? And defense counsel presented very detailed facts. There were these guys. They were all from the same area of Jamaica. They were called the Gaza Boys. They had messed around in another club a couple of weeks ago. And what the court says was, well, now you're proffering facts, and I understand that, but you have the burden to prove the factual basis for your objection. That's all the court was saying, and that's all the court did. He then made us go first. We agreed and acknowledged we had the burden to prove the enhancement, and the court placed it on it. And we know that because the court, A, because of the presumption, but B, because the court made us go first in presenting evidence. And we did present evidence. B.
Well, counsel, did he make y'all go first? I mean, it looked like there was that discussion and almost you said, yeah, we'll go. I mean, it was, to me, from reading the record, a little unclear that the court made you go first. It seemed like that's what ended up happening almost voluntarily, which, I mean, I get the presumption part. Without the presumption, it's a little bit more confusing to me, quite frankly.
I think, Your Honor, characterization is fair. I mean, the court has discretion, even if it doesn't place the burden of proof on one party, the court has discretion as to how evidence is presented at a sentencing. But just one factor to consider is the fact that we did go first. And I think it was ultimately, we agreed we had the burden, and then the court said, well, okay, put your evidence on. So I think you can infer certainly that the court, you certainly can't infer from that. I don't think it would be appropriate to infer from that the court reversed the burden that we all had agreed applied. I think it's also telling that when the court explained its ruling, it tallied the evidence that we had proved, that we had introduced, that it viewed as tending to exclude self-defense. It didn't say, obviously, he didn't act in self-defense, and all this stuff proves otherwise. The court tallied affirmatively.
Let me ask you a question just a second. In talking about the evidence that the judge recounted to you, he said the DNA directly connecting the gun to the defendant and the gun being found at the defendant's house, I think is very, very compelling and doesn't support a claim of self-defense. Would you explain that rationale to me, please?
The way I understand it, Your Honor.
Finding the gun at the defendant's house disprove self-defense.
Your Honor, I think it's that information coupled with Stone's testimony that she didn't know it was there, And the testimony from Stewart that the defendant denied having anything to do with the gun. Or not having anything to do with being at the scene at all. He denied being at the club. He denied having anything to do with it. And the fact that they found a gun with his DNA, he didn't call the police, say, hey, I shot this guy, here's the gun. He hid it in his house, is a fact that the court considered as tending to exclude self-defense. Because if it were self-defense, what we argued was he should have called 911, said, hey, these guys were shooting at me and I acted perfectly lawfully in shooting them. Instead, when police talked to him affirmatively, he said, I don't know anything about the club. If my girlfriend was there, she must have been cheating on me, is what he said. And that I think the court could consider as one factor among several tending to exclude self-defense. But the court also found that he armed himself at the scene. That video showed, and there was multiple videos, but they only showed Oliver shooting. That he unloaded the gun. He didn't just fire one shot, he fired 5. That all the shell casings pointed to Oliver. And that Oliver, as I mentioned, tried to prevent the authorities from finding the gun. And when the court said there are gaps in the evidence, that was in response to an accusation by defense counsel that we had reversed the burden of proof. And all we said was, Your Honor, the defendant didn't testify, so this court has to rely on the other evidence, that is the circumstantial evidence. And the court said, well, how does that reverse the burden of proof? And that's when the defense said, well, they didn't even call the victim. And the court said, I don't understand how that's reversing the burden of proof. It just means there's this gap in the evidence. And I think the defense even conceded. He's talking about a gap in perhaps direct testimony. What the court had to do was rely on circumstantial evidence to make its finding. That doesn't suggest that the court applied the wrong burden when evaluating that evidence. I think it's simply an accurate statement of fact, one that the defense attorney didn't take issue with. He actually said, well, I agree with that, Your Honor, as far as it goes, and then moved on to something else, didn't accuse the court. In fact, I don't think the defendant ever accused the court of reversing the burden of proof before the district court. The court said, of course, there's no other evidence at the scene of other firearms. There's no other evidence at the scene, and that was in the context of a discussion of the shell casings and the video, which is evidence at the scene. So I think it's an accurate statement. There was no other evidence at the scene of firearms. There was some testimony that Smith had a gun. I don't believe there's any evidence. There's no evidence, certainly not in the testimony or even in the defense memoranda, that Oliver ever saw Smith with a gun. But the fact that there was some evidence that Smith had a gun a few blocks away at the tropics is just not relevant evidence at all, because both parties agreed, and the district court explicitly said a couple times, the standard focuses on the defendant's state of mind. Did he know he was facing an immediate threat of death or serious bodily injury is the standard for self-defense. And there was no evidence that suggested, in the light of the evidence that we introduced showing that he was the only shooter, there's no evidence suggesting he was responding to a threat posed, an immediate threat posed by Smith with a gun. So I don't think there's anything wrong with that statement.
When the bouncer, the security guard, fled, what do you think he was afraid of? He had nothing to fear himself?
No, Your Honor, he did testify that someone had a gun, but he didn't testify that Smith had a gun. And he stated, he wrote in the memorandum that the defense didn't introduce at sentencing, but had submitted to the probation office earlier, he said that someone had actually pointed a gun at Oliver, but Akalatse said Oliver never pointed a gun at anybody, or I'm sorry, Smith never pointed a gun at anybody. So not only is there no evidence that Smith pointed a gun at Oliver, there's affirmative evidence that he did not. That was evidence that was actually introduced by the defense. But given certainly, I don't think anyone disputes that there's evidence that somebody had a gun in that parking lot, which was probably enough to make the security guard want to leave. It's just the security guard didn't say anything about Smith and Oliver, or even Stella and Oliver. The evidence is that Stella tried to get a gun from Brian's car, and Brian refused to let him do it. So there's no evidence that Stella was armed with anything other than a beer bottle, which isn't sufficient to create deadly force, the kind that justifies shooting somebody, can justify shooting somebody. I do want to turn, if the court has, I'm happy to answer questions about the enhancement, but if not, I'd like to turn to the supervised release conditions. The court appropriately imposed conditions 5, 8, 12, and 16, I think they are. The court explained that its entire sentence, not unlike, say, McMiller, the court didn't say, here's the sentence I'm imposing, here's the prison sentence I'm imposing, here's the reason. The courts basically did it in 3 parts, said, here are the considerations for the entire sentence. I want to make sure I'm deterring particularly people who possess firearms illegally and furthering all of the 3553A factors, and I'll state a sentence no greater than necessary to do that. Then he talked about prison. Then the court talked about supervised release. And then the court responded to each specific objection. Condition 5, which is about approving a place, the probation officer is approving the place the defendant lives. He said defense counsel argued it's an improper delegation of authority. And what the court said was, I don't have a constitutional or statutory problem with that one. And that's a sufficient explanation because this court's review of that issue is de novo. Vague or improper delegation is de novo. There's no difference in the words of this court in Comer to the district court's statement. So you know the district court considered the argument, and you know the court didn't believe it to be unconstitutional. So if there were a substantive challenge to that condition, which there's not in this case, but if there were, this court would be fully equipped to determine whether indeed that condition violates Article 3 as an impermissible delegation of authority. Condition 8, which requires him to obtain permission before associating with felons, the court said it's too broad because the probation officer can just come back if he finds him associating with a dangerous person and take it before the district court itself and have the district court modify the conditions. And what the court said was, no, the reason we have these conditions is so the probation officer doesn't have to bring this to court. In other words, the court thought it was fine that the probation officer exercised this discretion. Again, if this court wanted to evaluate the substance of that analysis, it could. There's enough information to enable appellate review, which is the standard for the explanation of a sentence under the Supreme Court's decision in Chavez Meza and Rita and several other decisions. And then 12, that one, the court, again, it was a vagueness and non-delegation question. The court said the court is overruling the defense objection. Obviously didn't believe it was unconstitutional. That's sufficient for this court to do so. And we know that because the defense actually raised the constitutional arguments. So the court can evaluate it. It's not vague. It has all of the features that this court has said make a condition not vague in Comer and in Van Donk. It has a common sense understanding. Risk was ordinarily understood to mean the risk associated with your criminal history and your crime.
But did he give any, I'm sorry,
Yeah,
Judge Davis.
No, go ahead.
I mean, on that one, I mean, my reading of it was the only explanation he gave in overruling the objection was that Judge Bell had done it.
I don't think so, Your Honor. The court did mention that, and I don't think it's
I
particular.
know that was going through a lot of them, and in some of the issues, that was one of many issues. But are we talking about 12, the risk?
The risk notification one, Your Honor. I think the court did mention that, but the court also said, I'm overruling the defense objection. I do think the defense attorney, unfortunately, I don't have it, I didn't write it down, but I think the defense attorney had actually said it's the same objection I made earlier. So when the court said I don't have a non-delegation problem, it was perfectly fair to say, okay, I don't have this problem here either, and just say I'm overruling the objection. But the point is, the standard only requires this court to show that it considered the objection and provide enough explanation to enable appellate review. The amount of explanation varies depending on the condition. And when the only argument is a pure question of law, one where the district court's opinion really doesn't matter because it's purely de novo. This court said in Comer, no deference to the district court whatsoever. The court doesn't have to say much. The court just has to give this court enough to know that it heard the objection and considered it. And it rejected it on these constitutional grounds. If this court thinks it's unconstitutional, then it vacates the condition. If this court doesn't think it's unconstitutional, which is purely within this court's province, then it upholds the condition. That's enough information for this court to complete its appellate review of that condition.
And what's your argument with respect to the constitutionality of 12?
It has all of the features that make it not vague. The defendant has the ability to clarify the meaning by its own inquiry, and especially in this case, because you're talking about just notification of risk. So either the probation office says to someone directly, look, maybe he, before you hire him at this gun shop, you should know he's prohibited from possessing firearms, something like that, or tells him what he needs to notify someone. So there's no danger that he's going to unwittingly violate it, which is another factor that applies, because really there's not any risk of that in any event, because conditions, you can't be prosecuted for violating a condition you don't know about. Can't be punished for inadvertent violations, in the words of the court. And of course, the defendant can bring an as-applied challenge in the future if he's ever somehow accused of violating this condition under circumstances that would be vague. Those are the circumstances this court held in Van Donk and in Comer make a condition not vague. Even if there's some question about gray areas or what conduct it covers at the margins, there's no risk of a Fifth Amendment violation here because of it. And then the second part of it is
the implementation. I guess maybe your answer is it has to be this way, or otherwise it would be unworkable. But isn't this entirely within, with respect to 12, within the discretion of the probation officer with respect to its application to this defendant?
Whether it's within the discretion of the probation officer to notify someone about a risk, but it's not within the discretion of the probation officer to punish him for violating the condition, which is a critical factor when talking about the second argument, which I think your question relates to, which is it an unconstitutional delegation? I think the first step on that is we're talking about providing notice. That's the only thing this condition requires. And that's obviously not something specifically reserved to the district judge as opposed to court personnel. Court personnel can give notice consistent with the Constitution. But beyond that, the district court established the core principle. We're only talking about risks, and whether that's construed narrowly or broadly, it's a principle established by the district court, not by the probation officer. And then the court retains ultimate responsibility for deciding whether the defendant violated its terms. And this court has upheld far broader delegations. In Hamilton, it was pretty much a blanket ban on the internet. In Comer, it was a ban on social networking accounts. In Van Donk, it was a ban on pornography.
Let me ask you a question. Isn't 12 no longer a standard condition?
It's no longer a standard condition in the Western District of North Carolina after October 1st, 2021. So
is it being used outside or as a non-mandatory condition?
Well, the court continues to have discretion to impose it in any individual case because the standing order doesn't preclude the court from doing that. The standing order just basically serves as language the court uses for imposing standard conditions. The court, of course, has to make an individualized determination in every case. But as far as I know, the court does not ordinarily impose this condition anymore. That said, I don't think that affects the constitutionality of it or the propriety of the court's explanation in this case.
So where was the individualized determination with respect to this defendant that condition 12 was an appropriate condition of supervision?
Well, the court chose to impose these conditions, chose to impose the standard conditions, and that provides some indicia of an individualized determination. And the court also went through each one of these conditions and modified several of them in response to the defendant's condition, in response to defense objections. And that had nothing to do with what other district judges had said. The court revised, for example, 9 and revised 13, not because there's nothing in the record suggesting that was to mirror some other district judge's thing. That was simply in response to the particular circumstance.
When I was preparing for this case, I was struggling to figure out exactly how 12 would apply in this context of someone who's accused of firing a weapon and being a felon and all of that. And I guess you came up with an example. If he were to be seeking employment in a gun shop, the probation officer might well be, it might well be appropriate for the probation officer to tell the defendant that he needed to alert that gun shop owner of his prior conviction.
Yes, Your Honor, I do think that highlights a point, though. This is not a particularly onerous condition. It doesn't limit the defendant from doing practically anything other than perhaps not disclosing that information if required to do so. But it doesn't limit his ability to get a job. It doesn't limit his freedom on a daily basis. It's a very, very mild intrusion on the defendant's liberty interest. And, you know, the thing to keep in mind always when evaluating these conditions is it's a defendant on supervision. These are his active sentence. He's serving an active sentence, and it's for 3 years in this case. Condition 12 and 16, I see my time is almost up. I just want to mention, everyone has agreed it's a clerical error. The defendant has not disputed that there's a clerical error in those. Clerical error can be corrected under Rule 36. There's not any kind of dispute about what the scope should be. We've agreed to the very language that appears in the defendant's brief, and that's currently before the district court. So it does not require resentencing. Thank you for your time.
Thank you, Mr. Enright. Ms. Hester?
Thank you, Your Honor. With respect to the government's point about sufficiency of the evidence, in our briefs, when we addressed that question, it appeared to us from reading the government's brief that he was only bringing that up in the context of the clear error, the court's clear factual error. But in the context of the burden shifting, we did say that if it's not a de novo review, that this would be clear error if the district court had applied it. So we did not waive anything there. If anything, it's a misunderstanding of what the government was trying to say in its brief in relation to the district court's factual finding. As far as the government's assertion that the defendant wanted to confront these victims, I think that you have to look at the videos to see why that's just simply not a reasonable interpretation of the evidence. A lot of this evidence came from the videos. One is the video in the KFC drive-through lane where you can see the defendant falling out of the car. He never gets back in it. He gets close to it, and that, we believe, is the point where he grabs the gun. We know from the government's actual statement of relevant conduct that's in the PSR, when Oliver finally did get in the girlfriend's car, the security guard at Dirty South overheard him saying to her, "Why didn't you leave? I told you to go." So it's apparent that at the point where he grabs the gun, he's telling her to get out of there. Be safe, get out of here. Because he thought they were after him and he wanted her to be safe. Another critical piece of evidence, which unfortunately I overlooked during the briefing, is the videos from the Cash America pawn shop. That is the building that is actually right next to the Tropics nightclub. And if the court looks at the November 1st outside cameras, cam 2, you actually can see on there the girlfriend's white car parked on the curb and the activity that's happening in the parking lot of the Tropics nightclub. And that gives a real sense of how compressed this time frame was. Because from the time she leaves that parking lot, you can see the car that pursues her the headlights are shining on her car. They are watching her. She is on the phone with the defendant trying to figure out how to meet him. And as soon as she pulls out, you see two men run on foot in the direction that she's gone. And this car pulls behind her or follows her. And then a second car follows her. So this whole time she's on the phone communicating with him. There was no point where he stopped fleeing. He was running this whole time, just trying to figure out how to get out of there. And the government says he should have gotten in her car and left, but that didn't make sense either because they were being chased by two cars and they reasonably believed that the men in these cars had guns. So that would not have assured their safety anyway. Mr. Oliver took the only action that he reasonably believed was available to him at that point to save himself and his girlfriend from either death or serious bodily injury from these aggressive men who they believed had guns and were chasing them. With respect to the supervised release conditions, I think what the government hasn't answered is the fact that at the beginning of the discussion about supervised release conditions, Mr. Oliver reminded the court that it had an obligation to explain specific to Mr. Oliver why these conditions applied to him. And with respect to the ones that we are challenging on appeal, the court just never did that. It addressed some, it rejected his argument that Oliver the probation officer could just come back to court on the felon association, but it never addressed his argument that that shouldn't even apply to him in the first place. And it never gave a reason why the risk notification condition should apply to him at all. It never explained, other than it just disagreed, why the search condition should apply to someone who's not a sex offender. The court just simply didn't do what this court requires, which is to give reasons based on the facts of this particular case, why these conditions satisfied the statutory requirements and didn't constrict his freedom any more than reasonably necessary. Thank you.
Thank you, Ms. Hester. Mr. Enright, Ms. Hester, thank you both for your arguments this afternoon. The case has been well presented, and we very much appreciate your arguments. Thank you very much.
Thank you.
Okay, going on to the third case. And just, we'll hear from you.
May it please the court. Good afternoon. My name is Devin Senges. It's an honor to be here today. It's made especially more meaningful because of who I represent, one of the most courageous women I have ever met, the petitioner, Mrs. Veronica Toledo Vasquez. Mrs. Toledo Vasquez is petitioning for review of the Board of Immigration Appeals' denial of her asylum claim. The board adopted and affirmed the immigration judge's holding that she had not established past persecution or well-founded fear of future persecution based on a protected characteristic, and that there was no nexus to that protected characteristic. The board focused exclusively on whether family was a particular social group, and in the alternative, finding that perhaps it was, that she had not established that family was one central reason for the persecution that she suffered. I hope to put to rest the board's first conclusion rather quickly. It was legal error for the board to hold that family is not a particular social group for the purpose of asylum eligibility. This court has held for many years that family is a quintessential and prototypical social group under the three-part framework. And additionally, the singular case for which the board relied upon in finding that family was not a particular social group, matter of LEA, has since been vacated by the Attorney General in its entirety. The government rightly did not attempt to defend this particular finding in its brief before you today. Moving to the next.
Can I ask a question? I need that. Would you tell me who all the members are of the family members of your client?
So my client is a member of the particular social group family of Gisela Toledo Vasquez. My client is the sister of Gisela Toledo Vasquez.
I understand it, but I want to know who all the members of this family are. So if you would just list them 1, 2, 3, 4, 5, I would appreciate it.
So as this court wrestled with in Velasquez, family is often a moving target. One could define family as nuclear family, which would be parents, siblings, and children. Certainly, Mrs. Toledo Vasquez, my client, was at one time a nuclear family member of her sister, Gisela Toledo Vasquez. At the outer reaches of your question, Your Honor, this court has found that at the very least, cousins and uncles are family for the purpose.
I want names, please, of all the members of the family members of your client.
Of my client's family, she would consider her family to be her parents, her siblings, her spouse, who unfortunately was brutally murdered, and her children.
How about, so that would include the 3 sisters and 4 brothers that she has?
Yes, Your Honor, certainly she would say that.
All right, would that include Francisco's parents?
Certainly she would consider her parents-in-law to be members of her family, correct?
All right, I don't know how you say this name. Is it Watrago? Could you tell me how to pronounce that?
Watrago, yes, Your Honor.
All right, would Watrago's mother be a member of this family?
I would have to ask Veronica, Mrs. Toledo Vasquez, if she considered her.
No, this is a legal question.
Brother-in-law. Legally speaking, kinship has never been defined as to its outer borders. All we have is what this court.
Do you consider her a family member of your client? That is Watrago's mother.
No, Your Honor.
Okay, and is Watrago a member of your client's family?
Yes, Your Honor.
Okay, thank you. That answers my question.
Yes, Your Honor. And this court at least has relied upon its definition going all the way back to the board's seminal decision in Matter of Acosta, where Matter of Acosta identified kinship ties as a quintessential social group because of the immutable characteristics that the members shared. Based upon this court has recognized clan membership as well in the vein of family. And certainly my client is closer in relationship to her sister than the petitioner in Crespin Valladares, who based his particular social group of family on his relationship with his uncle, as well as the family relationship claimed in Aquino, Córdoba, where the petitioner claimed persecution or family membership based on his relationship with his cousin and his uncle.
Counsel, could I follow up with some questions kind of related to the ones you just mentioned? As I read the IJ and the BIA opinions, and the BIA here adopts and affirms, so I think we consider them both. Do you agree with that?
Yes, Your Honor, I do.
That they relied on the fact that the persecution, the actual persecution and the threats of persecution all occurred after or in response to intervention and assistance to your client's sister, correct?
Correct, Your Honor.
And they relied on the fact that some of that intervention and assistance was from family members, like your client, but some of it was to non-family members, correct?
Correct, Your Honor. That was one of the stated reasons.
And they did. I can't remember if this was stated or not, but there were. Was there evidence of family members who did not assist and intervene to help your client's sister, who were either threatened or physically persecuted?
Yes and no, Your Honor. No, in the sense that every family member of Gisela Toledo Vasquez who was physically present in Mexico intervened based on their familiar relationship with Gisela, felt motivated to intervene. That would be my client, her husband, and their sister Angelica when she was in town visiting family. All other family members are residing in the United States and were unable to physically intervene.
So what you're saying, your answer to my question is that all the family members who were
capable
who
of
were there
did in fact
intervene.
And they did in fact suffer persecution. Tragically, of course, Francisco Toledo, my client's husband, was brutally executed and beaten in front of his 3 minor children. And Angelica submitted a sworn declaration to the record testifying that she was subjected to death threats, that she took credible enough to flee back to the United States.
Do we have a case on our circuit where the persecution on account of a family membership, we've held that to be on account of family relationship as an appropriate nexus, where the persecutor is a member of that family?
I do not believe so off the top of my head, Your Honor.
Do you know of one from another circuit?
Certainly, the Board of Immigration Appeals in matter of ARCG found that a persecutor was the husband because he was persecuting his wife due to his misogynistic beliefs as to the inferiority of the female gender.
Yeah, but the account was on the basis of gender rather than family relationship.
Correct, Your Honor.
So what I'm trying to find out if there's a case from the BIA, from our circuit, or from any other circuit where there's been a claim for asylum or withholding on account of a family as the particular social group, where the persecutor has been a member of that group.
Not that I've found, Your Honor, but this being one of the government's main points, I'd be happy to dive into this a little bit with you. Under the doctrine of ejusdem generis, and excuse my rusty Latin, we cannot categorically hold that just because the persecutor is a family member, close or distant, that the petitioner cannot meet the burden for asylum. This would mean that any young man who was persecuted because of the gender of his choice of partners or sexual orientation could not claim eligibility simply because the persecutor was a family member.
But that would be an entirely different social group in that instance, right?
But we look to, as the Congress has laid out the different protected grounds, we look to see what similarities they have in order to guide us and instruct us.
Well, that's a dangerous argument for you. There are a lot of people would say family groups don't have anything to do with the specified grounds Congress laid out. I realize we got our cases to deal with, and that's one thing. But yeah, I'm trying to figure out in response to what Judge Diaz said, your answer to my question seemed to focus on whether or not other social groups besides family members would be whether that would be protected grounds. So, yeah.
Certainly, Your Honor. This court has held over and over again, as has every court who has considered the question, that kinship ties are a cognizable particular social group under the Act. The question for nexus in this court should be taken on a case-by-case basis, and no bright line rule should be established.
So what is it about this case that distinguishes it from Velasquez?
If this were an equational Velasquez case, Your Honor, I would stand here before you representing Gisela Toledo Vasquez. This court in Velasquez said that a purely interpersonal dispute between two people who were disputing over a common interest was beyond the reach of asylum eligibility. Here, it would be a great surprise to the persecutor and my client to discover that they were in an intrapersonal dispute. In fact, the record is littered with evidence that the persecutor, Rogelio Huitrago, saw my client as sticking her nose into business where he considered it did not belong. The record is littered with evidence that my client saw, or that Rogelio Huitrago saw his dispute as with his wife, and that anyone who dared intervene into that personal dispute was not minding their own business.
And that's whether they're a family member or not, based on the record, correct?
So whether or not other individuals suffered persecution at Rogelio's hands is beside the point. My client's claim is based on the personal and direct threats that she suffered and whether there was a causal nexus between her family membership and those threats.
So how can you, aren't we obligated to look at the record? And if what you said is true, which is a fair point, I think anyone who intervened in Trago's business, he persecuted. And there's evidence he did that of family members. There's evidence he did it of non-family members. Isn't the fact that the record indicates that he did it with non-family members part of the record we look at to determine whether the nexus you assert is correct?
I disagree, Your Honor, and I believe the immigration judge was in error to do so. This court has said it is a too narrow line to draw or analysis to make to ignore the motivation. If someone is going to place themselves into a dangerous situation and into the crosshairs of a dangerous individual, a situation they would not otherwise have been in, this court has said if their motivation for doing so is based on familial ties, then the nexus ground is established. This court held that reasoning in Hernandez-Avalos and in Cantillano Cruz versus Sessions.
But in Hernandez-Avalos, there were 3 different instances of persecution. 2 where the gang members threatened the mother when she wouldn't hand over their son for gang membership. The first persecution was about whether she would report the persecutors to the police after she identified the body. And at least in a footnote, it's all but said that that first persecution wouldn't be something that was on account of. And isn't that what we have here? We have persecution on account of sticking your nose in the bad guy's business. And he seems to be a pretty equal applier of that rule, family members or not.
But this court has held that if you're sticking your nose into that business because of a familial love, then it's a meaningless distinction to focus on the immediate trigger, revenge for, say, going to the police or testifying in a trial of some sort, and the very relationship that prompted the individual to take that action in the first place. I have an example, but I see my time is up. I don't know if you would like to hear it.
Finish your answer to Judge Quattlebaum's question.
So a great example, and I believe my case is indistinguishable from Cantillano Cruz in that respect. In that case, Mrs. Cantillano Cruz specifically went down to the docks where the murderer, Mr. Avila, was doing illegal operations. And Mr. Avila specifically told her to butt out and mind her own business if she knew what was good for her. The IJ short-sightedly focused on Avila's stated, or his statement, which was to mind your own business, and too narrowly discounted the very relationship with her husband, Johnny Martinez, that prompted her to go down there in the first place.
Thank you.
Judge Diaz, can I ask a question?
Certainly, yes, please.
I'm still trying to straighten out who are members of these different family groups. With regard to the family members of Guisela's Toledo Vasquez, is Veronica a member of that family member?
Yes, Your Honor.
Is Angelica?
Absolutely.
Are Guisela's parents members?
Certainly.
How about Guisela's 3 sisters and 4 brothers?
Certainly, the family is close. She would say that her siblings are family members.
All right. How about Francisco?
I say that, yes, Your Honor, a in-law relationship is a family relationship.
And Francisco's parents?
I'm not sure what Gisela would think of that. I would say no.
With Trago's mother?
Certainly, that would be her mother-in-law.
and Watrago.
Yes, her
So-
husband.
Okay, thank you, Judge Diaz. That answers my question.
Yeah, I have a follow-up to the question I asked you earlier about Velasquez. So I know you distinguish Velasquez, and the argument you made is that this is a different case in the sense that you've got people who are loggerheads with each other and not necessarily, and your client sticking, as you described it, her nose into somebody else's business quite appropriately, I think, given the familial connections. But what is your position with respect to Velasquez? Do you think that case was correctly decided given our prior precedents, or are you simply content with distinguishing it on the facts of this case?
I agree with the court's two premises in that case, which were one, that there was not enough evidence to, that substantial evidence held that there was only one motivation in that case, and that was fighting over the custody of a child, the grandmother and the mother. And the court's floodgates arguments were well taken, that transforming any interpersonal domestic dispute into a potential asylum case would be dangerous. But I do believe that this case is not equational to Velasquez and is much more equational to cases like Hernandez Avalos and Cantillano Cruz.
And what is it that makes it different, again, just so I understand your position?
That my client did not have a dispute of any kind with Mr. Watrago, and Mr. Watrago did not consider, from his very mouth, did not consider himself to have a dispute with my client. It was only the familial love for her sister that motivated her to take actions that the immigration judge and board narrowly and inappropriately focused on. This court has called immediate triggers.
Yeah, well, so I'm not sure how that's different from Velasquez. Up until the fight over the custody battle, I don't know this, but I assume there was no dispute between those family members up until the fight over who should take custody of the child.
Both Mrs. Velasquez and her mother-in-law, Mrs. Estrada, wanted custody of this child. My client wanted nothing from Rogelio, and Rogelio wanted nothing from my client.
And you think that's a distinction that matters? For
In
purposes of asylum?
In Velasquez, certainly the case found it instructive and informative. I mean, it was the very thing the case was based on, that this was an intrapersonal dispute between two individuals.
Okay, thank you very much.
Thank you.
Miss Burns, I see you there on the screen, so whenever you're ready.
Good afternoon, Jessica Burns on behalf of the respondent, and thank you, Your Honors, for allowing me to appear remotely today. This case comes down to one issue, and it's whether Ms. Toledo met her burden of establishing that Rogelio targeted her because of her relationship to her sister and not because of her meddling in his marriage and agreeing to testify against him. In this
Ms. Burns, I'm sorry to cut you off so early, but you laid out the two reasons why she may have been persecuted, but those two reasons don't seem to be exclusive. They could work in tandem. And don't our cases say that at least when familial relationships are one central reason, if not the central reason, but at least one not insignificant reason for the basis of persecution, that's enough. So why isn't that this case?
Well, this case is different from those, and the court has certainly found where the two bases are intertwined, there's a sufficient nexus. The court looks at whether the applicant was targeted rather than another person because of the protected characteristic. And here, the significant difference is that Rogelio targeted non-family members in addition to family members for intervening in his relationship and agreeing to testify against him or leading to his arrest. He struck his own mother in the face when she tried to protect Gisela. He went after one of Francisco's friends who helped capture him, leading to his arrest. He targeted Francisco's parents, who called the police and again intervened in the relationship. And it's important to remember that the particular social group alleged in this case was family members of Gisela Toledo Vasquez.
Yeah, so Ms. Burns, I'm sorry. So you laid out the motives of Watrago, but why are we focusing solely on the motives of Watrago? Aren't the motives of the person being persecuted equally as relevant?
No, Your Honor, the relevant inquiry is the motive of the persecutor, not the victim. And the case law is clear on that. And it's been consistent that's what's relevant here is the motive of the persecutor only. And so while Ms. Toledo may have been motivated to act to protect her sister based on their family relationship, there's just nothing in the record that compels a finding that that's why Rogelio acted. And this motive is supported by Ms. Toledo's own statements that she made in court. That
Well, let me ask you about a sort of gang cases where we've got cases where gang members are motivated to try to force the child of a mother to join the gang. It seems to me that those motivations are equally as indiscriminate as with tragos. They don't really care about the familial relationship. They just want somebody added to the ranks of their gang membership. And yet we say that because of the fact that the mother in that case was motivated to prevent that from happening because of her familial ties with the child, that's enough. It's just hard for me to understand what the difference is in this case.
So the difference is in the cases where the court found nexus, there was but for causation, but for the victim's relationship with the family member, they wouldn't have been targeted. So, but for Ms. Hernandez-Avalos' relationship with her son, she wouldn't have been targeted by the gang. Here, we don't have that same but for causation because Rogelio went after other people who were not family members. So it shows that he wasn't motivated by the familial membership. Rather, he was motivated by the meddling in his relationship and the agreement to testify against him. And this motive is supported by Ms. Toledo's own statements in immigration court. She said that the robber told her, the robber that came after Rogelio was arrested, told her, don't go getting around into things. When asked why she was being threatened, she said it was because she got the police involved in Francisco's murder and because she was going to testify as a witness. Again, when she was asked why she'd be harmed upon her return to Mexico, she said, because I was the principal witness. She was targeted because she meddled in the relationship, and she is one of the main reasons that Rogelio went to prison. And so because of that, that makes this case different from the other cases where the court has found a sufficient nexus. This case is much more akin to Velasquez v. Sessions, where the applicant and her mother-in-law fought over custody of the child and ultimately led to threats and murder of the applicant's sister. And the court found that the mother-in-law was not motivated by a familial relationship. Similarly here, the familial relationship is merely incidental to Rogelio's decision to act.
Counsel, can I interrupt you and talk about those two arguments? On the one hand, the nexus isn't met, or the nexus isn't met because there's persecution of non-family members. And I understand that argument. But then you're also saying it's like Velasquez, which is a completely intra-family dispute. Are those two arguments inconsistent?
They're not, Your Honor, because the mere fact that the family relationship exists and perhaps motivated Ms. Toledo to act to protect her sister does not mean that that is why Rogelio was motivated to attack the people that meddled in his relationship. Also, Velasquez, unlike the other cases that did find nexus, similarly lacked the but-for causation that is lacking in this case that I mentioned earlier. Again, this case is also similar to Cedillos, where the record showed that the threats could have been directed at any person who interfered in the relationship or contributed to Rogelio's criminal prosecution. There's nothing in the record that compels a finding that Rogelio acted because of the familial relationship. And petitioner hasn't identified anything that would compel that finding.
You have anything else, Ms. Burns?
I don't, Your Honor.
Judge Traxler, you have any questions of Ms. Burns?
No, thank you, Judge Diaz.
All right.
Thank you for your time.
Yes, ma'am. Ms. Sengiz, you have some rebuttal. I want to ask you first about the distinction that you're adversary on this other side made that essentially says that the motivations of the person being persecuted are completely irrelevant to the analysis. Do you agree with that?
I do not agree with that, Your Honor. This court has said that where a person's family connection is the motivation behind them taking an action that then causes persecution, which this court has called an immediate trigger. So in this case, Veronica agreeing to testify or aiding the police against Rogelio, any motivation that causes someone to take that action is indistinguishable from their family relationship. It is meaningless to say that that family relationship is not the but-for causation that Ms. Burns says is lacking in this case. The government cannot explain. I mean, the government focuses a lot on the fact that other people attempted to aid Ms. Gisela and perhaps experienced some types of harm, but the government cannot explain why Mrs. Toledo Vasquez, my client, would have taken these actions but for her relationship with her sister. But for her love and loyalty to Gisela, she would not have agreed to take any action against Mr. Huitrago at all. She would not have aided the police in any kind of action against this man. She would not have agreed to move against him in any kind of criminal or civil trial involving him. It was solely her love, her sacrificial love for her sister that motivated her to again and again put herself in these dangerous positions. But for her relationship with Gisela, she would not have been involved with this man at all. This court called it meaningless to distinguish that family love and the actions that a victim has taken that attracts the ire of some of these persecutors. Again, Cantillano Cruz and Hernandez Avalos are the two main ones. It's also...
Counsel, can I follow up? Does that answer your question sufficiently? Just and by the way, I think the record is replete of the courage and love your client showed. So please don't take any of my questions to suggest otherwise. But in those cases, did the record show that the persecutors, like the record shows here, were persecuting non-family members?
Certainly in Cantillano Cruz, Mr. Avila was considered a general criminal actor. The MS-13 and Hernandez Avalos were, the government used the same argument in that case that because MS-13 harmed large swaths of the population, that somehow diminished the nexus or affected our nexus analysis in this court. I believe it's disingenuous for Mrs. Burns and rather selective of her to cite only portions of the record where Mrs. Toledo Velasquez says she was targeted because she testified as a witness. In fact, the record is replete with evidence that shows that she and the persecutor evidence that she was harmed because of her family relationship. For example, on the record of page 120, the persecutor's own sister told Mrs. Toledo that she was sticking her nose into the matter and she would be sorry. Mrs. Toledo Vasquez says on page, in fact, in the very beginning of her testimony on page 93, when asked what kind of problems she had in Mexico, she had sister problems, not Rogelio problems, indicating she saw that this was because of the actions that she had taken to protect her sister. On page 165, Gisela herself tells Mrs. Toledo Vasquez, "You have helped me so much before that Rogelio tells me one day he will hurt you." On pages 166 and 458, Mrs. Toledo Vasquez terrorized that Mr. Huitrago was terrorizing her, sending her a message about what would happen if she continued to help Mrs. Toledo Vasquez, referencing her sister. The proper opinion or the proper analysis for the immigration judge and the board to take in this case going all the way back to basics, is whether or not Mrs. Toledo Vasquez's relationship with her sister was one central reason for the harm she suffered. And that has to be more than a superficial reason. Surely love for one sister, no reasonable adjudicator could claim that that is a superficial reason. Indeed, in this case, it was a sacrificial reason, as it led to the ultimate price, the murder of her husband, the loss of her 3 children's fathers, and forever losing the ability to live in peace and safety in her home and native country. Thank you.
Thank you, Ms. Singh. Thank you both for your able arguments this afternoon. We appreciate it very much. At this time, the court will stand adjourned until tomorrow morning.